good morning, everyone. Now that we have everybody connected and through our various technical challenges, thank you for joining us today and for coming to hear about the new Colorado Privacy Law 1128. My name is Mitch Tanenbaum. I'm a partner at CyberCecurity. With us is also Monica Minkel, a regional director at USI. Monica, do you want to do a little introduction of yourself?
Thank you. USI is the largest privately held insurance brokerage in the country. We have more than 150 offices throughout the United States, and our mission is to bring the technical resources and knowledge that's normally reserved for the Fortune 500 down to the middle market, to the small and medium-sized businesses that we all know and love. I run our management and professional services practice group, which includes professional liability, cyber liability, and other similar types of products from here in Denver. And our placement group handles cyber placements from the little tiniest, 2-employee shops all the way up to those Fortune 500 companies when we have those opportunities.
Thanks, Monica. And as I said, my name is Mitch Tanenbaum. I'm a partner in CyberSecurity. CyberSecurity is a full-service cybersecurity consulting firm, and we do everything from assessment to mitigation to incident response to education, and this is part of our education activities. So Ray, please change the slide.
Okay, I have now, but it's not indicating that it's happening right over here. Is there
we go, it just changed.
It changed? Okay, all right, so you guys are seeing it because over here it looks like it's not working, but okay, great, it's working. Move forward.
Okay, so the history of this bill is that it was introduced in January, so just very recently. There were a number of unpublished versions. The Colorado Attorney General was intimately involved in things, and the governor signed the bill on May 29th. Very unusually, there was not a single no vote in either house of the legislature, so that kind of gives you an idea of the amount of support behind it. It goes into effect in just a couple of days, on September 1st. And this is part of a growing trend on a number of states to, in fact, now, as of this year, all 50 states have a state privacy law, and many of them have enacted new provisions, have increased the amount of data that's covered, have increased the penalties, and just in general making things more consumer friendly. So next slide, please. So one of the changes in this law is the definition of who is a covered entity. And in this case, a covered entity, what they've added is anybody who maintains effectively a list of data of that's personally identifiable in the course of their business. So if you do this at home for your own personal enjoyment, you're not covered. But if you are in business, and that includes a one-person business, a two-person business, or a Fortune 100 business, if you maintain a list of customer information or visitor information, and that to be a customer, as well as more traditional, if you own a list or you license a list, then you're covered by this law. And a person is pretty much any kind of legal entity, from an individual to a trust or a partnership, and an unincorporated. It really doesn't matter who you are covered. So this is one of the unusual aspects of this law. Everybody is covered. There are no exceptions and no exemptions. So next slide, please. This law also preempts HIPAA and GLBA in certain aspects we'll talk about later. And unusually, most of the time the government likes to exclude themselves from these laws. In this particular case, there's actually a whole separate parallel part of the law which includes local government agencies. So if you're a city, a town, a county agency inside of Colorado, you are also covered by this law. Next slide, please. Monica, you want to talk about what personally identifiable information is?
Sure. Personally identifiable information, we often refer to this as PII, is any two pieces of information that together can be used to identify a person. Okay, so this includes social security numbers, a personal identification number, like my kids have the ID number for school, a password, a passcode, an official state or government issued identification card, whether that's a driver's license or something else, your passport number. Biometric data has become a bigger issue the last several years now that you're getting retina scans and those types of things. So any type of identification number that with that piece of information, one other piece of information, they can figure out who you are. In many places, they may consider an email address to be personally identifiable information, and in California, they even consider a zip code to be personally identifiable information. So this definition keeps growing.
Thank you. Next slide. So one of the challenges always in these laws is, well, what is it that I, as a business person, need to do? And in Colorado, the way the law is written at this point is you have to maintain reasonable security procedures and practices. Next slide, please. So one of the things that they don't do is they don't define what's reasonable. And ultimately, and Monica, I'll let you chime in on this in a second, it boils down to what it is you can defend in court as reasonable. Our definition of that is best commercial practices. And we're hoping that the Colorado Attorney General is going to make some definitions of things that she has not yet, but the law hasn't gone into effect yet. And we're actually reaching out to her to see if we can assist in that. So any thoughts on that, Monica?
Well, I think it's important to remember that allegations are not always proven, but can be very expensive to prove that you did, in fact, take reasonable commercial practices or reasonable accommodations to make sure that information was safe. And as we start getting farther into our presentation, I think it's important to remember that anytime you have to defend yourself, it can be very expensive. And that's really a benefit to having some sort of cyber insurance coverage in place, is to help protect from that financial component. Defending yourself whenever you have good practices is certainly easier than defending yourself when you didn't have good practices, but there's still a cost to that no matter what.
Absolutely, thanks. Next slide, please, Ray. So the bill, in addition to requiring that you have good practices yourself, it also requires that you ensure that any third party that you share personally identifiable information with, and it doesn't matter whether that third party is in Colorado or not, whether that third party is protecting your personally identifiable information that you've been entrusted with or that you've collected to the same level, the same degree that you have. So this means that in particular, the big one here is cloud service providers. So if you're using some cloud service, and just I can name a couple of big ones like Salesforce or Dropbox or Box or something like that. If you are using one of those services, it requires one of two things: either that you ensure that the third party is protecting the information, and that means you want to have, in particular, you want to have something in your contract that talks about that, or alternatively, you can assume the liability for their bad security habits. Now, I'm not a lawyer, but I don't think it's a really good idea. And in addition, based on a lot of stuff that's been in the news here locally, there's a specific part of the law that particularly talks about secure disposal of documents, and that means whether they're paper documents or electronic. And this law, by the way, does not make a distinction between information you're storing electronically and information you're storing on paper. Any thoughts on third-party protection, Monica?
Mitch, as you know, we often see companies utilizing third parties to assist them with a lot of their technology and information storage. The problem with that is whenever you hire a third party, you are accepting liability for what they are doing. even if you have a contract that says perhaps you have limited liability, does your vendor have sufficient means to take care of you if something goes wrong? If you hire that vendor, you may find yourself taking care of all of their mistakes. It's very important as you go through this process that you make sure your vendor has proper insurance and that they have proper financial backing to be able to pay some sort of damages in the event that something they've done causes you harm.
And really, all the contract does is it gives you a leg to stand on when you go to sue them. It doesn't actually protect you or absolve you of any liability. So I think what Monica's saying is right on and important to understand. Next slide, please. And as we've been saying, and will continue to say, cyber risk insurance can assist that. But insurance should never be your go-to defense. It should always be the last resort, right? What you want to do is go protect yourself and to the best of your possible ability, go off and avoid a breach situation, because you know, the reputational damage alone is a serious problem that you'll deal with. So you don't want to count on, well, insurance will make me whole, because it ultimately never does. You know, 5 years later, we're still talking about Target and its breach, Home Depot and its breach, Anthem and their breaches, you know, and so on and so forth. So,
and even if insurance can make you financially whole, I will tell you, I haven't had a client yet that didn't get emotional whenever they had some sort of cyber attack or cyber breach. So it is important to make sure that you are doing the right preventative measures up front. But insurance really does two things for you, and it provides those extra expenses to help you deal with the crisis at the time. And in the event there is legal liability, whether it's from the state of Colorado, which we have a couple of clients dealing with some state issues right now, or from customers or other interested parties, you have liability coverage as well.
Because remember, in the situation where you have a breach, not only can you get in trouble with the state, but you know, a customer can sue you as well. So, you know, the cyber risk insurance will help you in that case as well.
Absolutely.
So, next slide, please. So one of the things that is new and improved, I guess you could call it improved, in the Colorado law is there's a requirement to notify those people affected within 30 days. The 30 days is the shortest notification period in the country. There are no extensions allowed like Florida, which allows you to extend that several times. And there is also no exception for people who are covered by HIPAA and Gramm-Leach-Bliley. So if you are a healthcare provider, financial services institution, you have different notification requirements under HIPAA and GLBA, but you still have to notify those affected in Colorado within 30 days. So that's a real challenge, because the only way to do that is you have to have a pretty good handle on who was affected and what was taken. In order to be able to do that, we'll talk about later what you have to tell people in your breach notification. There are a couple other situations where you have shorter notifications. One of those is for DoD contractors, Department of Defense, and the other is for GDPR, which is for those folks doing business in the European Union. Those both have a 72-hour notification period. But beyond that, in terms of general regulation, this is the shortest notification period in the country.
And it can be hard in those first 30 days to even know for sure what happened or who all was impacted. It's where it's nice to have a partner who's able to help you figure out what happened and what law you do need to comply with there in that very short period of time.
Absolutely. The insurance carriers, while they're not in the business of providing breach services, they will have relationships, and they will also have a response coordinator in their incident response team who will be able to help you and make sure that you're complying with the things you need to comply with. So next slide, please. Depending on the size of the breach, you must notify the Colorado Attorney General if you have more than 500 people affected by the breach, or if there's more than 1,000 people, you have to notify the 3 big national credit reporting agencies. So those are 2 additional folks that you have to notify, and you have to kind of navigate your way around in order to be able to make sure that you're complying with the law. Next slide, please. So I talked about this a minute ago. Monica, you want to talk about what people need to tell in their breach notification?
Certainly, and remember that these laws may vary a little bit by state. So if you have customers in multiple states, you may have multiple law that you need to comply with. The notification, in order to comply with Colorado law, must include the date of the breach, a description of what information was stolen, and I can tell you most of our clients struggle with figuring out exactly what went out the door. Information on how to contact you, phone and addresses for credit reporting agencies, and also the information for the website for the FTC. There may be additional requirements for online account breaches. And again, cyber insurance and their response teams can really provide you with some resources. I always think of them as G.I. Joe guys dropping in with parachutes to come in and help you whenever you do find yourself in a crisis like this.
I mean, hopefully you're in a situation where if you have an incident that happens very, very infrequently, as a result of that, it's going to be something which you're not very practiced at dealing with, whereas the incident response team at the insurance carrier will be in a much better position to be able to assist you with that. Next slide. So there is one exception. This is an exception which is very common in most all states, and that is there's no duty to notify if the data was encrypted. But there's an exception to the exception, which is that you have to be able to show that the means to decrypt the data wasn't taken as well. So, you know, if you have a situation where the data was encrypted, but the attacker came in as an authenticated user, and that user had access to the data, the system is going to go decrypt it. The fact that the data was encrypted really doesn't help you very much, and certainly doesn't provide you with an exception. So if your strategy is to go off and say the data is encrypted and we don't need to notify anybody, then you better have a plan to be able to explain how the encryption keys were not taken at the same time. Next slide, please. Okay, so one of the considerations to think about here is if you are an investor of some sort in a company, you're buying, selling, or investing in a company, you know, when it comes to cyber risk, you're more than likely you're assuming that cyber risk. So if you're acquiring the company, you are acquiring a liability. If you are selling a company, you are hopefully disclosing the liability. We saw that with the Yahoo Verizon acquisition and the big hullabaloo over that, and they managed, you know, reducing the sale price by hundreds of millions of dollars as a result of that. You know, the good news was that it happened before the close. Good news for Verizon, bad news for Yahoo. But you know, if you're an investor, you could wind up losing your entire investment. So you know, that's obviously a problem there as well. Any thoughts about that, Monica?
I think the important thing to consider is as you go through your due diligence process for any type of acquisition, divestiture, or even an investment, digging a little bit deeper in how cybersecurity is managed at the target company, you probably want to look a little bit more closely than maybe we've looked in the past. Oftentimes, we don't even discover a breach until after an acquisition has occurred, but there are things that were going on long before the company was acquired. So really looking into cyber diligence as part of your analysis process, I think is very, very important.
And part of that is making sure that you understand how the cyber risk insurance that the selling party has and the cyber risk insurance that the purchasing party has, how they dovetail, and you don't accidentally do something where you wind up with a non-coverage situation as a result of changes that you make during the acquisition process.
Very true.
Next slide. So one of the things here is what are the potential consequences of this law. So the first thing is, unlike the new California law, which we're doing a webinar on next month, there's no private right of action here. So that's the good news. The bad news is that there's both civil and criminal penalties potentially here. The law does not specifically say, unlike the California law, the law does not specifically say that you can sue for $322.95 per record breach. What it says is that the Attorney General may sue to gain compliance or to recover damages. So that's a pretty broad definition. It doesn't put any limits on it whatsoever. And it also says that any local district attorney or the governor can ask the Attorney General to bring criminal charges. So given that district attorneys tend to be somewhat political animals and typically seeking higher office, you know, the odds of a DA in any kind of high profile situation going off and asking the Attorney General to go off and pursue criminal charges is a higher probability than any of us may like. And obviously cyber insurance can help with that and will help with that. Monica, you want to talk about that?
Again, defense costs are certainly important. Many of the high quality cyber insurance products today also will cover fines and penalties where they're insurable by law. So it's really nice to have some sort of financial safety net if something does go wrong.
Thanks. Next slide, please. So what is it that you should do? And here's kind of, this is the action item list. Number one, creating and implementing a written information security program. They're called by different things in different industries. But basically, this is the go-to book of your overall cybersecurity program. This is actually required by the law. You should have this. You know, it doesn't have to be super long. You know, a lot of ours are, you know, for a small company, less than a dozen pages. So but it does talk about all the different things that you need to do in your cybersecurity program. Next slide, please. Second thing to go do is to designate an individual as responsible for the program. If nobody is responsible for the program, it's just not going to happen. So it's important that you designate someone, and that person should be someone that's high enough up the management ladder that they have access to the executive team, and if your company has a board, to the board as well. Because from a board perspective, this is a board legal responsibility to go manage this program. And in many of the breaches, we see the board members get sued individually or collectively as a board for failing to do their fiduciary responsibility. And go ahead.
It's also important that whoever's managing your information security program, number one, knows whether or not you have insurance and knows how to use it if they need it.
Absolutely. Next slide, please. You should conduct a risk assessment at least once a year. The purpose of a risk assessment is to figure out where the exposures are, because you're never going to have a situation where you're going to be able to close all the loopholes instantaneously. So just give that one up. What you want to do is focus on the ones that are high risk. You know, if you discover that you are a HIPAA covered entity and you know, you've never done a HIPAA risk assessment, or you're you know, storing things in the cloud and you've never looked at the security of the cloud vendor. A lot of different things can come up in a risk assessment, and it's a way to go off and focus management's attention. The risk assessment should have recommendations for mitigating the risks that were identified. Next slide, please. Monica, you want to talk about training?
Training is incredibly important. More than half of the breaches that we've seen have some element of employee error included there, whether it's accidentally sending out emails to the wrong people, using the same password in multiple places. Employee awareness is so incredibly valuable. Mitch and his team do an amazing job of on-site training with employees. Many of your insurance carriers may include some training online if you're a smaller company that you may be able to access at no additional cost. Employee awareness is incredibly important, and it doesn't mean really bad videos. You really need to make sure that your employees know what the expectations are to help you avoid having some sort of a cyber attack.
And if your insurance provider doesn't provide adequate video, adequate training, and in fact part of that training needs to be anti-phishing training, there are excuse me, a number of very cost-effective online platforms that have a whole learning management system built into it. for companies for say less than 25 employees, you can do that for something on the order of $500 or $600 a year for the entire platform and all the training material and the anti-phishing. So it doesn't have to be super expensive, and it is really, really critical, as Monica said. Number 5, create a disaster recovery plan. Boy, is that a disaster all by itself. If we look at my poster child for disaster recovery these days is the Equifax breach. If you go look at the various things that happened during the breach, they really, really, really did a bad job, including things like their PR team sending people to the wrong websites, their websites not being owned by Equifax, their websites having really strange HTTPS security certificates, lots of different things that they did wrong. And what that clearly brought out was they did not have an adequate disaster recovery plan. And having a plan, a piece of paper, is not adequate. You really need to actually test it at least once a year. That includes the team members of the disaster recovery plan, which will be the incident response team, need to be identified. They need to know what their roles are. They need to be trained in their roles and need to be given the appropriate tools to go off and do that. And it's critically important that you're not going off and trying to deal with that in real time. Next slide, please. Tied directly to that, you want to create an incident response program, which is, assuming you have cyber risk insurance. If we haven't kind of convinced you yet to buy cyber risk insurance, or you don't already have it, please strongly consider that. Working in tandem with the incident response team at your insurance carrier, you need to be able to do things like identify how the hackers got in, identify how long they've been there, identify what information they took or had access to, figure out whether the data was encrypted, as well as figure out how you're going to respond. And one of the other challenges that Equifax seemed to have is they didn't have a crisis communications team. Now, your insurance carrier can help you with that, or you can have a third-party crisis communication team. One thing I would point to, most cyber insurance policies require you to either use one of the insurance carrier's approved vendors or get the carrier's approval prior to incurring expenses that you expect the carrier to reimburse you for. So it's important to understand the terms of your policy. And we actually recommend, and all the carriers have all been very good about this when we've done this, is actually set up a call with your incident response team at your carrier to go off and work through the process and understand what it is that the rules are and what the carrier can provide and what the carrier can't provide and how it works. Monica, have some thoughts on that?
One of the first pieces of your incident response plan needs to be contact your insurance broker and your carrier and request assistance. And knowing who you can choose from as a vendor ahead of time will save you a lot of time and a lot of headache, especially whenever you end up finding out about your breach on a Saturday night and everybody's closed. So going through that process is really important. Make sure that you have clear information about how you notify your insurance company and how you engage their resources, because you're going to want to do that from the very first moment.
So the first thing your incident response team is going to be a core group of incident response team members. It might be, for example, your general counsel. It might be someone representing the board. It might be the CEO in a smaller company, your cybersecurity vendor. But it's going to be a small team. What you're going to do at that point is identify, how big this thing is. Is it bigger than a bread box? And who do we need to involve? Do I need to engage the third-party forensics firm that I already have a relationship with, that I have preferably a signed agreement, even though I haven't spent any money, so that I'm not dealing with trying to understand agreements and getting approvals and getting agreements signed. Another person that is a critical component of the incident response team at some level is going to be an outside cyber knowledgeable attorney. And I say cyber knowledgeable because most attorneys, are somewhat challenged to being able to turn on or off their computer. So you really want somebody that understands cybersecurity. You want to understand who understands the cyber laws and what's required to respond. That is also a mechanism that's required to protect attorney-client privilege. So that outside counsel may be an important consideration here. We obviously have recommendations for all these folks. Next slide, please. So the next thing to do, and I think people probably are beginning to understand this now. I don't think that it's perfect, but they're beginning to understand it. Is you've got to encrypt data. Now the challenge is understanding where your data lives. Nowadays, your data doesn't live in the data center. It lives in the cloud. It lives on laptops. It lives on third-party service providers. It lives on phones. Every place where data lives, and as part of the California law in particular, because of certain requirements it has, you need to make sure that you know where your data lives. It is important to understand where the data lives. It's really hard to go encrypt sensitive data if you don't really understand where the data lives. We do something called a vendor data inventory with our clients, and it's amazing where a client will call us up or we're talking and say, "Hey, I found 10 more vendors I didn't know about." Well, in one sense, that's great because now you know about those 10 vendors. You didn't know about them before. But on the other hand, it's 10 vendors who have your data, who are doing something with it, who you don't really understand the part about who's liable for it. If you go back a few slides we talked about earlier, and that's really not the best situation. It's clearly a lot better to go off and be in a situation where you have now found out that you have these vendors, but what you really would like to do is know who those vendors are in advance. So encryption, really critical at rest. Next slide, please. One of the requirements of the law and most state privacy laws is that you restrict access to data based on a need to know. So we see this especially in a lot of very, very small companies where everybody has access to everything. That's really a problem. So what you got to do is figure out, okay, how do I go do that? What controls do I put in place? And that includes data that lives in the cloud. Just because it lives in the cloud does not mean that you don't have to go off and manage access controls. So for a lot of people, an example of this would be human resources data, just as an example. Trade secret data is another category where if it gets out in the wild, if you can't show that you've used due diligence to protect it, you can't enforce your trade secrets. So it's pretty important that you manage the access controls for data that you are responsible for. And that, by the way, includes data that a client of yours has shared with you and you're now responsible for. So you don't necessarily, it's not just data that you own, but it could be data that you have in your care, control, or custody that is owned by somebody else.
And Mitch, it's important that you know who has access to data, that you can figure out on a moment's notice who has access to the information. We had a situation recently where a highly sensitive employee had kind of gone off the rails and needed to be removed from the systems, and figuring out how many passwords needed to be changed and how many access points needed to be closed off because this employee was leaving the company. It was quite a chore. So it's important to know if you have to turn somebody's access off, how do you go about doing that if they have access to all of these different points?
In fact, we were just talking to one of Monica's clients just the other day, and we were talking about this particular subject, and the conversation came up about restricting access, and they thought they had a pretty good control over that. And as the conversation went on, it became clear that they didn't. That they had people who had left who still had access to things, and they had subsequently cleaned them up, but it did not get cleaned up anywhere nearly as quickly as anybody would have liked. And so this whole thing, it can't really stress this enough. The vendor data inventory, understanding what data you have, where it lives, and who has access to it is really a critical component. And related to that, because you can't control access, the next slide please, Ray, is creating a data classification and document marking program, because that's the thing that's going to tell you, okay, this thing is, client proprietary information, or this is a HIPAA protected information, or this is trade secret, or this is, for some of our clients, they're in a situation where they're dealing with certain information which is export restricted. It's not legally allowed to be exported outside the United States. So all those things you need to understand in terms of the kinds of data that you're dealing with. And then employees need to understand what that means. So if they see something, to take the kind of a worst case scenario, ITAR restricted, which is this International Traffic in Arms Regulation, which is, we see that a lot in the defense business. You can go to jail for going off and not protecting ITAR information correctly. So, that's clearly a really extreme situation, but important. Next slide, please. The number 10, and I'm not seeing the slides now, so hopefully, Ray, I'm in sync. You want to implement a event logging and auditing capability appropriate to the risk, and the Colorado law talks about appropriate to the risk. So, if you're the corner candy store, your risk is very different than if you're a healthcare provider. So, with that understood, and also understood that you have to defend whatever decisions you make, then logging and auditing is really a critical part. When an event occurs, you're going to be going to those logs and trying to figure out what happened, and trying to figure out what data got compromised, who got it, what they got, how long they were in there, and things like that. If you don't have any kind of security event logging capability, then your ability to go do that is going to be severely impacted.
And Mitch, this can make a big difference in the cost of researching a data breach. If you have good logging and auditing, you can see the footprints in the sand where people went. It's much cheaper and much faster for you to be able to respond in 30 days and tell them what information was compromised. If you don't do this prevention work, it becomes much more expensive. Absolutely. And one thing I just thought of based on your comment, Monica, if you have these logs and you can't ascertain what data was compromised, who you have to notify goes down dramatically. We had a situation, we had a client that had a breach, and ultimately, because they had extensive logs, they were able to identify there were only 43 people who were affected. Well, that's given the client has thousands and thousands of customers, the fact that they were able to narrow this down to 43 people made a huge difference in how you go respond to the event. Responding to 43 people, you don't want to do this, but you could literally pick up the phone and call 43 people. If you have no idea who is affected, then you have to assume under the law the worst case, that everybody was affected. And that's really not a great situation. Number 11, next slide, please. If you haven't figured out yet this whole issue about third parties, everybody's using third parties. It's just a fact of life these days, and it's not going away. In fact, if anything, it's going to escalate. So you need to make sure that anybody who is a third party that you're sharing data with, you understand their ability to go protect your information and ultimately to protect your reputation. So a third party cyber risk management, this is different than the old traditional vendor risk management, where you're looking to see whether the vendor is licensed in the particular state, or whether they have insurance, or whether their registration with the Secretary of State is current. Yeah, that's important, but that's not cyber risk. Cyber risk is how are they protecting your data, and protecting your data, even if they don't have a direct connection into your system. If they have the ability to send you a Word document or an Excel file, or they have an ability to send you an email, then they are an attack vector. I mean, what we saw, for example, at Target, the attack vector was some little, and they'll probably be offended by this, but little mom and pop air conditioning vendor who fixed coolers inside of Target stores in the Northeast. That was the attack vector. That was ground zero. So, all of these vendors, even if they don't have a super sophisticated IT infrastructure, are an attack vector. The Home Depot breach was also caused by a third party, or facilitated by a third party. So understanding this third party vendor cyber risk management is a really critical part,
and it should be a formal program with a person who is responsible for it. And we have clients who are relatively small that have hundreds of vendors. Everybody from the office supply vendor, which is low risk, to somebody that you're sharing, protected health information with. So consider that and build a third-party cyber risk management program. Next question, next slide rather. Monica, you want to talk to this?
We've mentioned cyber insurance a number of times. Cyber insurance does two really important things. It provides you with extra expense coverage, so it reimburses you for money that you're spending to deal with a crisis, money that you would have had to come out of pocket had you not had some type of insurance. This includes things like notification expense if you need to send out letters. It includes things like credit monitoring. It includes any kind of forensic or additional IT resources that you need to help respond to the situation. Cyber also provides liability coverage in the event there's litigation, whether that's brought by the state, brought by a federal agency, brought by your customers, brought by another third party. You have defense cost coverage as well as settlement coverage if you are sued. So there's two very important components of the actual insurance piece. Cyber insurance is probably going to be the cheapest insurance policy you buy. It's not that expensive. We have programs that start at $500 and go up from there. And it's much, much broader today than it was 15 years ago. Most of the good quality cyber carriers include a number of additional resources that come at no cost to you, including sample policies and procedures, additional training and other resources that you may be able to use. When you do pay for a cyber policy, we encourage you to use those resources and augment those with Mitch and Ray whenever you need to. But that's a good place to start on a lot of the basics as far as securing the organization.
And another thing the policy will often give you is discounted services from preferred providers. These are providers that your insurance carrier has already vetted and has an agreement with, and as a result of that agreement, they have reduced prices for clients of the insurance carrier. So, even when you have to pay for things, you may be paying less if you're using someone that one of these proactive services that the carrier has built. Next slide, please. Monica, you have a thought?
No, that's correct.
Okay. There's a lot to this bill, not a lot of time. Hopefully, if people have questions, we still have some time there. But here's a link to the actual text of the bill, and obviously you can reach out to us later to go off and get your questions answered, as one of Monica's clients did just the other day. Next slide, please. So as I said, there's a lot of other states that are increasing the bill. What they're doing is they're doing a couple of things. They are increasing the scope of what they call personally identifiable information. As Monica said earlier, one of the big things that people are starting to include now is biometrics. They're increasing the scope of who is covered. The California bill has really expanded that dramatically. I say bill, it's really a law. They've shortened the notice. In the case of Oregon, has been reduced to 45 days. And some states are starting to realize that people are trying to finesse the system. So, for example, Oregon just said you're not allowed to tie credit monitoring, like Equifax did, to charging people a fee later. And so, the Equifax deal, a lot of them was, we gave you a year's free credit monitoring, but oh yeah, by the way, we were going to take your credit card number, and if you don't cancel it, we're going to charge you the next year. And Oregon and other states are saying, no, you can't do that. The California law looks a lot like the General Data Protection Regulation. It gives consumers an amazing set of protections, and that means that companies need to understand that. As I said, we're doing a webinar on that next month, so that's something you might want to look in your inbox for and join us. Next slide, please. Will it be easy? No, it's not, but is it worth it? Absolutely, because dealing with a breach, and I've dealt with many of them in my career, is just no fun. There's just no fun at all. Next slide, please. So for folks that don't know where to start, next slide, we have and this is the only ad that we have in here, we have an ad called the Business Cybersecurity Certification Program. And it covers probably 95% of businesses. Obviously, if you're a larger business, you have, industry-specific requirements, things like that. That's not going to cover you. But, for a relatively manageable amount of money, we give you a lot of things: policies, procedures, training, incident response, just a whole bunch of things. And also our industry certification at the gold level, which says that you have an active cybersecurity program and that we've vetted it. And that also includes hands-on support from our team. You can just go to that website, or you can just Google Business Cybersecurity Certification Program and learn about that. So with that, we have time for questions. Ray, do we have any questions?
We didn't get any questions, but I'm thinking that's pretty unusual. I'm thinking that has something to do with the system this morning. So I've got some questions here that came in on the last event that we did with Monica, which was a week or 10 days ago. So I'll give you these questions right here because they were great questions.
Okay.
So, is there a special category of insurance coverage related to the cyber due diligence, a purchase or sale of a company?
Sounds like a Monica question to me.
Yeah.
And again, the due diligence process itself often can be covered under a transactional liability or reps and warranties policy. Sometimes we'll see an extension from the D&O policy for that as well. Mitch made a great point that the biggest piece of your due diligence process needs to be understanding their infrastructure exposure and also making sure that those cyber policies, if they have one and you have one, that those are going to work together seamlessly.
There's another question that came in last week that I thought was a great one. If we have a small breach, should we report this to the insurance company? Will they raise our rates?
So those are really two different questions. I'm sure Monica will have an opinion about that, but I'll give you my opinion first. There's no such thing as a small breach. You never know where it's going to lead. And if you go off the rails and go off and do stuff without including your insurance carrier, and this small breach turns out to become a big breach or a bigger breach, you're going to be writing a large check out of your own checking account, and you probably don't want to do that. Will they raise the rates? Possibly a little bit. Right now, the market's very competitive. So, I would not expect, dramatic rate increases. But, you also don't want to be writing a check for $50,000 out of your own pocket because you didn't report the breach.
And to back up what Mitch is saying, often the cyber insurance that you're buying isn't the largest part of your insurance spend. If there's a little bit of an adjustment in premium, it's probably not going to be that much because there is such a competitive environment. We have seen a number of cases that started out looking like they were pretty small and developed very quickly into very expensive breaches. We would much rather you use the insurance that you have than try to pay for something out of pocket. You don't want to be in a situation where you've got late reporting or they don't cover the loss because you didn't properly notify the carrier. So I don't care how small it is, please report the claim and make sure that you have the experts helping you in dealing with the situation.
Obviously you've heard what Monica and I have to say about that. That is in some sense a legal question. So you definitely want your legal counsel involved in that. But our recommendation is to report it always.
Please, here's another question. Please provide a use case for this Colorado law. How is enforcement likely to happen?
That's an interesting question. I think that's still up in the air. The most likely situation is going to be that there's a breach, and the breach became public, and now there is an outcry. So, if it's a really small breach and nobody knows about it, nobody reports it to the news media, or the news media doesn't pick it up on their own, then the odds of an enforcement action happening are low. However, that being said, there's absolutely nothing to stop a disgruntled customer or vendor of yours who was hurt from going out and independently talking to either the Attorney General's office or the local district attorney and saying, gee, you know, do your job, Mr. or Miss District Attorney or Attorney General, and go after these guys. So more than likely it's going to be in some kind of breach situation, but it's not, doesn't even require that the breach be public. Although that's certainly, you know, if that happens, then you're going to wind up with a lot more of attention on that. Monica, you have any thoughts about that?
I think you covered it. Thanks, Mitch.
Okay, thanks.
Okay, another one. We do business in both California and Colorado. How does the California law compare to the Colorado law? And then there's a couple more little questions here. Are they the same? Do we need two cybersecurity programs?
So let me expand that actually a little bit. As I said earlier in the presentation, there is a cyber breach notification law in all 50 states now. We added Alabama and South Dakota this year. So now all 50 states have and several territories have a cyber breach notification law and privacy law. So you're actually harmonizing your program with the laws of all 50 states. The California law is really off in a world of its own. And you know, just like in 2003 when California implemented Senate Bill 1386, which was the original California privacy law, and everybody thought, you know, they'd gone off the rails one more time, and now the California law is the model for the rest of the country. The California law is way more strict. It's much more like what is going on in the European Union. So for folks that are doing business in the European Union, you have yet a whole other set of requirements. But you do not need to have multiple programs. What you're going to do, you know, unfortunately, is you're going to go off and model to the strictest law, California being an exception to that. You know, if you're one of those folks that is lucky enough not to have any clients in California or any visitors to your website from California, then you're probably, you know, can evade the California law. But certainly from a privacy and security and reporting standpoint, for example, the Colorado law has a 30-day reporting requirement. Well, if Oregon has a 45-day, as I was saying earlier, you know, and you report in 30 days, well, that one program is sufficient. Certainly, if you do business in California and you are required to comply with the California law, you know, complying with the California law is going to be an absolute superset of what you're required to comply with under the Colorado law.
And again, I think it's important to remember that the location of your customer or the person who's protected health information or protected personally identifiable information, where that person lives is what's important, not necessarily where you are doing business. Where are your customers coming from?
Absolutely. That's the challenge, because, you know, nobody, you know, yes, the corner candy store is still a local business, but, you know, most people have an online presence. Most people do, you know, a portion of their business on the internet. And when that happens, then all of a sudden now you are no longer a local business. The set of businesses who are considered local businesses is now a much smaller set than it used to be, because people do business on the internet.
One last question. What if our data is in the cloud in a third-party application that we don't control? How do we audit this?
So I'll talk about auditing in a second, but I think Monica can talk about the third-party risk and the insurance component of that, because it's important to understand that you need to make sure that your cyber risk insurance does cover that. So for larger companies, they're already going to have a cyber risk program, and you can ask them about, you know, what they're doing, and they will have prepared information. There are also third-party companies like Vendorly and CyberGRX, to name two of them, that will go off and do risk assessments of your third-party providers. There are also companies like BitSight, which is a great tool that will actually do risk assessments of your third-party vendors without their knowledge or approval, which is really pretty cool. So ultimately, you are responsible. Sometimes you have to get creative, and we can certainly help with that. But from an insurance standpoint, you want to talk about the third-party coverage?
again, the important thing to remember here is that if it's your data, it doesn't matter where you're holding it. If you own the data and it is stored in the cloud, you are responsible for it. Make sure that the way that you have your cloud provider set up, that you have logs turned on, that you're managing access to that information. Your most likely issue with a cloud-based storage is that the wrong person gets into it, probably because they guessed somebody's password. I mean, you really have to look at how are you securing that information. If it is your data, you are responsible for securing it properly and for making sure that any kind of breach, you have to own that kind of a breach as well.
And the last thing that I want to say about that is yeah, we have seen certain cyber liability coverage, which does not include data under the care, control, and custody of third parties. Now, I would say that any moderately competent insurance broker would not let you agree to something like that, but unfortunately, we have seen several policies that fall in that category. And so it's important that you do talk to someone like Monica, who is very knowledgeable in the cyber risk insurance game, because it is not a standard form policy in any state, and it's a bit of an a la carte process. You know, do I want business email compromise coverage? Do I want third-party coverage? Now, hopefully, because these additional coverages are so inexpensive, it's really, you know, sort of ethically unresponsible of an insurance agent not to go off and give you those coverages. But if they don't know the business well enough, they're not even going to understand that they're not doing it right.
That's all the questions.
Well, thanks. We're actually out of time. You know, Monica's email address, as mine, is on the screen here. Feel free to reach out to either one of us if you have a question. Thank you for your time, and come back and visit us when we talk about the California law. And I think that's it for today.